Hi folks, and welcome back to Conveyancing. This is video 3 in our video series on seller disclosure. And you will remember that in video 1 we had a look at disclosure obligations at law and defects in title. And in video number 2 we started to have a look at the various different statutory regimes that bear upon the issue of a seller's obligation to disclose. And now we come to the BCCMA. And the regime for the BCCMA applies for both existing lots as well as proposed lots in a community title scheme. Now, if you had a look at your tutorial materials for week 1, there was a quick discussion in there of exactly what a CTS is. No real magic in that. It is simply a bunch of jointly administered lots of land. Those lots of land are administered via a community management statement, and the community management statement is usually registered, and that will set out things like, who's going to be the body corporate manager, and the bylaws and rules that will apply to the residents in the community title scheme, and all community title schemes have to have some common area, some common property. So in a residential complex you usually find that things like the shared pool and the shared gymnasium will be located on the common property somewhere. So that's a community title scheme. So the BCCMA deals with proposed lots in a CTS as well as existing, but the regime, as I said, for proposed lots mirrors that in the Land Sales Act. In terms of the disclosure requirements, so you'll see there all of the same usual suspects that we encountered in the land sales legislation. The buyer needs to serve the seller a disclosure statement before entry into the contract. Ideally, that should be done separately from the contract, just to make it abundantly clear that you as seller are ticking all the boxes that are required under the legislation. We know that the disclosure statement has to be signed by the seller. It's no good being signed by the solicitor, is it? Because PASCUF tells us that the solicitor's authority won't extend that far unless they have been given explicit authority by the seller to sign such things for them. 213.4 requires a disclosure statement to be substantially complete, so obviously you can't back out of a purchase of one of these lots on mere trivialities. Disclosure statements have to be accompanied by a disclosure plan. The requirements are set out in 213AA, and there is that further requirement to correct inaccuracies. If you find that the disclosure plan has become inaccurate in some way or was always inaccurate in some way, then you are obliged to go ahead and correct those inaccuracies under 214. Again, much like the land sales legislation, there are a stack of termination rights that are triggered for non-compliance with this legislation. So under section 212A, the buyer is going to get the right to terminate if there's been no proposed community management statement served upon them. Under 213.5, read together with 205A, the buyer is going to get the right to terminate if the seller fails to provide a disclosure statement either at all or before the contract, or that's not substantially complete, or that hasn't been signed. Okay, so I wasn't mincing my words when I said a stack of rights to terminate. Under section 214.4, if there is a further statement served to correct inaccuracies in that disclosure plan, obviously if there's been material prejudice, you've got that 21-day window to terminate there. Or if there is something inaccurate in the disclosure plan and no further disclosure statement was served, you can terminate also in those circumstances. 217B provides an interesting kind of overlapping right to terminate where the original disclosure was inaccurate but there was no further statement served. Note, however, that has an oddly different time frame within which the right must be exercised. 217 provides a whole further list of rights to terminate, which I won't bore you with right here. You can go and flesh those out for yourselves, as well as 217A. Those rights deal in particular with contribution schedules and interest schedules that are all part and parcel of buying into a community title scheme, and they're far more complex. I'll leave you to read the text there. Under the BCCMA, as I said, the regime also applies to existing lots as well as proposed lots. And the regime in terms of existing lots is pretty much similar to what we've just run through here. So that's in Chapter 5, Parts 1 and 3. So that's the BCCMA. And now we come to the interesting little piece of legislation on urban encroachment. And started with the Planning Urban Encroachment Milton Brewery Act 2009. I don't know if you've ever driven past the 4X brewery at Milton while it's brewing. I have, and it smells terrible. And I can imagine that neighbours around that vicinity also thought that it smelled terrible. And as you can imagine, there were stoushes around that. So the original piece of legislation was designed to basically protect the brewery from neighbours having pot shots at it, trying to sue it for, spewing forth various smells into the environment and so forth, particulates in the air and so forth, generally speaking, nuisances. And that was then carried into the Sustainable Planning Act. And then from there, the regime was widened and placed into the Planning Act 2016. Chapter 7, Part 4 continues this urban encroachment regime, and you can see there the purpose is to protect existing uses of particular premises from certain effects of encroachment by newer uses, new kids on the block, in the vicinity of the premises by providing for registration of these favoured premises and establishing the responsibilities of persons in the area to which the registration relates, and restricting particular proceedings in connection with emissions coming from the registered premises. So it's about protecting generally economically important businesses from people constantly suing them, particularly where they were in the area first. Section 267 allows registration or renewals of registration of premises, and the good old Milton Brewery has been renewed just recently. Its registration was renewed for another 15 years, and I think I've put some links in the study materials for you there to the media release around that. The relevant minister was very happy to announce that the registration had been renewed and talked about all the jobs he was saving. Now you're thinking, how does this all apply to the issue of a seller's disclosure obligations? Well, if you happen to be making a development application in an area that's been affected by a registered premises under the Planning Act 2016, then you need to, when you are making your development application, request that the Registrar of Titles record on the title for that lot that the part applies to that lot, so that searches on title will reveal that that lot is in an affected area. For buyers, if a contract has been entered, as I say down the very bottom there, and the development hasn't requested that that note be put on title, then the buyer can terminate as long as it's before completion. So that is urban encroachment. Okay, so next we come to energy efficiency and the Building Energy Efficiency Disclosure Act of 2010. This one's all about disclosure in relation to large office buildings. So as you can see there, a net lettable area of greater than 2,000 square metres. There's a number of different obligations to disclose there, and there can be significant penalties that get applied. I'm not going to go into this a great deal because the focus for us is more in terms of residential premises at this point, but you do need to be aware that the legislation does apply if you are looking at transactions that relate to large office buildings. Next, we come to the exciting neighbourhood disputes legislation. There are two main parts to this legislation that you need to be aware of for our purposes. the fences provisions and the trees provisions. As you'll know, or as you'll read in the text, the legislation sets out various obligations that neighbours have to one another in relation to fences. You are entitled to a sufficient dividing fence for your property, and there are obligations for your neighbours to contribute where there is none there, or if it needs to be maintained or repaired. There are squabbles that happen in terms of contributions to the cost of fencing, or you have other issues like, you know, neighbours attaching things to fences and the other neighbours being very annoyed that the, you know, whatever it is that's been attached is whatever it's doing to the fence. Similarly with trees, you know all about that from torts, I would suspect. In terms of nuisance, the kinds of nuisances that trees can cause to the neighbour on the affected side. Usually, problems like this, if you think back to video 1 in this series, these kinds of disputes would tend to revolve around issues of quality of title. So, you know, if a seller is in dispute with their neighbour, you know, it's not, generally speaking, something that would go to a seller's obligation to disclose. However, the REIQ contract does cut across a seller's obligations here, and we'll look at this more when we do the REIQ terms, probably in video 4. So the main issue here in terms of the fences provisions is where a seller is in dispute regarding a fence with their neighbour, and they've gone off to QCAT, the Queensland Civil and Administrative Tribunal, to sort it all out, and there is the possibility of an order being made about this fencing issue. Is this the kind of thing that needs to be disclosed under the REIQ standard terms? If it does, it would come under the clause dealing with orders affecting the property, and the text basically says, I don't know whether it would or not. Arguably, it's saying that they're saying that it could be an order affecting the property within the seller's warranties. There is an alternate view, as I said, that these really orders that should be disclosed under clause 7.4 sub 2 of the REIQ standard contract should be restricted to really matters that are serious, matters that would actually affect title, rather than just quality of title, like I was saying before. So as far as I'm aware, we haven't had any decisions on that yet. Safest bet would be to just go ahead and disclose if you're in some kind of serious dispute with your neighbour, and there may well be a possibility of QCAT issuing some orders. I would just go ahead and fess up if I was the seller. If orders are issued on or after the contract date, the REIQ contract takes care of that. They're going to be the buyer's responsibility. And after the contract date, if a notice is received at that point in relation to a fencing issue, then the seller needs to give a copy of that to the buyer. In terms of trees, there's slightly different provisions. In the neighbourhood disputes legislation, it says that if a person selling is affected by an application or a QCAT order, the seller has to give the buyer a copy of the application or order before entry into the contract. At that point, then the buyer will be joined to the proceedings or will be bound by the order, and if no notice has been given, then it's going to trigger a good old termination right on the part of the buyer. So that is neighbourhood disputes. So now we come to pool safety, and much like the neighbourhood disputes legislation, we don't have to labour this terribly much, because we'll circle back round and cover it again when we're looking at the REIQ standard contract, because that deals with this. But just under the Building Act 1975, that legislation is divided up into ordinary private pools and shared pools. So private are called non-shared pools, and the kind of pool that you'd find in a residential complex, for example, would be a shared pool. Owners of these relevant regulated pools have disclosure obligations, as I say in the slide there. Two ways that you can go about it theoretically. If a pool safety certificate has issued, if you're in a happy situation as seller and you have one of these little beasties in your hot hands, then a copy has to be provided to the purchaser before settlement. So you can do it after contract, but before settlement. Failing that, if no pool safety certificate has issued, then you need to put the buyer on notice. Okay, much like the building safety legislation that we looked at in the first of these pieces of legislation, it's all about providing the buyer with sufficient information to work out if they want to stay in this contract or not. If no pool safety certificate has issued, the owner gives the buyer a notice of no pool safety certificate before the contract, and if there is still no certificate after contract and before settlement, then there are further disclosure obligations. The seller has to give another notice of no certificate to the buyer and also the Queensland Building and Construction Commissioner. If the certificate has actually issued after contract and before settlement, then you have to give a copy of the settlement, the certificate to the buyer at or before settlement. What are the ramifications if you don't comply? Not a lot contractually. The owner commits an offence, okay, but the contract isn't invalidated. That is an open contract, is not invalidated. And as I said, the situation under the REIQ standard terms is very different, and we will circle back and look at that probably in the last video. If the buyer takes with no pool safety certificate, then obviously they are going to have the premises inspected and get a pool safety certificate. So they will have to perform all of the works that are associated with that. Shared pools have a similar regime, but I will leave you to flesh that out from the text there. And I suppose you're thinking, are we at the end yet? Are we there yet? Almost. Two quirky little pieces of legislation and then we're done for this particular video. And you'll find them crop up in coastal areas like the Gold Coast. The Coastal Protection and Management Act is the first one, and that little regime says that the seller has to notify the buyer of an undischarged coastal protection notice or tidal works notice. So if you're a seller and you have any of these notices applicable to your property and they are undischarged, you must provide notice to your buyer not less than 14 days before settlement. So after contract but before settlement is okay here, folks. If disclosed, then the buyer is going to be bound. If there's no disclosure, then this legislation purports to say your agreement will be of no effect. Ooh, no effect unless the buyer notifies of an intention to settle despite non-compliance, or after settlement, the buyer may affirm the sale despite the non-compliance. So, interesting and potentially nasty little piece of legislation there. The last one, yay, is the Gold Coast City Council Local Law number 17. And locals like me are fairly well aware of this one. It's basically the council covering itself in terms of maintenance of what they call specified works, specified prescribed works in and around Gold Coast waterways. So things like revetment walls, jetties, pontoons and so forth. That particular little piece of subordinate legislation says that a clause has to be inserted into your sale contracts regarding maintenance and upkeep of these specified prescribed works. Section 15.3 gave the buyer a right to terminate for settlement for failure to comply, and this is what your text says. However, there was a very substantial amendment to the Property Law Act in 2017 and that inserted a new Section 57A, and that's Section 57A, so that there's no longer any right to terminate under local law for a seller's failure to comply with the disclosure required by the local law. So have a look at the new Section 57A of the PLA. Don't know if you were aware of that or not, but it certainly has had an impact on local laws like this little Gold Coast number 17 cannot any longer purport to give the buyer a right to terminate for failure to comply with that subordinate legislation. So that's it, folks, for my roundup of the basics of the legislation that may bite upon the issue of a seller's disclosure obligations. And that will be the end of this video. When we come back in the next video, we will have a look at the position under the REIQ contract and the kinds of disclosure that need to be made under those standard contracts. So, bye for now, guys.